Hi, today's session is on the unit Principles of Criminal Law, and my name is Shazia Khan. The learning outcome we'll be doing today is learning outcome 3, which is to understand the legal liability requirements for criminal damage and theft. But before I go into learning outcome 3, I just want to give you an overview of what we did in the last session, which was learning outcome 2, which is to understand the classification of violent offences. In the last session, we looked at the element of classification of different offences in the UK, such as summary, either way, and indictable offences. We also looked at assault offences. We looked at categories such as offences against the person, which are direct physical harm to individuals, and public order offences. We looked at homicide offences such as murder and manslaughter with reference to cases. We also looked at the subcategories, which are voluntary manslaughter, involuntary manslaughter, and corporate manslaughter. We then went on to look at assault offences. So we had looked at common assault, assault occasionally bodily harm, which is ABH, and GBH, which is grievous bodily harm as well. And we looked at Section 18 and Section 20 of the Offences Against the Person Act 1861. We then went on to look at sexual offences and public order offences as well. We looked at factors that influence the classification and the level of harm. We looked at the legal framework and key legislation, which is the Offences Against the Person Act, Criminal Justice Act, Public Order Act, and Sexual Offences Act. We also looked at outlining violent offences. We looked at common law, assault and battery, Offences Against the Person 1861, Section 20 and Section 18. We looked at homicide offences such as murder, manslaughter, causation. We looked at the thin skull rule and breaking the chain of causation in detail, and medical intervention. And we looked at cases with regards to that. So we also looked at discussion of certain examples in the cases of R. Blow, 1975, R. Paget, 1983, and R. Cheshire, 1991. We went on then to look at 2.2, which looked at the defences of loss of control and diminished responsibility. We looked at the common law offence of murder, the mens rea, and the defences. We looked at loss of self-control, elements of loss of self-control, such as loss of self-control and qualifying triggers. We then went on to look at diminished responsibility, and we looked at abnormality of mental functioning, substantial impairment, and causal link. And we looked at the recognised medical conditions. We then went on to look at comparison between the loss of control against diminished responsibility. We looked at 2.3, which is an analysis of actus reus and mens rea of common law offences against the person. We looked at assault and what the actus and mens is in regards to assault. We did the same for battery. We looked at legislation. We looked at the Coroners and Justice Act 2009 with reference to cases. We then went on to look at the analysis of actus reus and mens rea, so elements for murder. We looked at the death of a human being, the mens rea of murder. We looked at key elements such as intention, direct intention, oblique intention. And we looked at case examples in highlighting actus and mens rea. We also looked at elements of the actus and mens for different cases, and looked at the actus and mens for unlawful killing, causation, human being, and Queen's Peace with reference to legal authorities such as R. and Vickers, 1957, R. and White, 1910, AG's reference number 3 of 1994, R. and Wooling, 1998, R. and Blow, 1975, and R. and Gibbons, 1918. So we looked at a lot of case law in regards to elements of unlawful killing, causation, actus reus, mens rea, murder, homicide. So this is just a summary of what we've done in learning outcome 2. So now we're going on to learning outcome 3, which is to understand the legal liability requirements for criminal damage and theft. So to understand that, firstly, is what criminal damage is, and that's really important to identify in regards to elements of theft as well, and it's someone that defines someone who causes criminal damage as a person without lawful excuse, destroys or damages any property belonging to another, intending to destroy or damage any such property, or being reckless as to whether any such property would be destroyed or damaged. Indicative content for learning outcome 3 is we look at the Criminal Damage Act 1971, subjective recklessness. We look at Section 1 of the Criminal Damage Act 1971, aggravated criminal damage. Section 5 Criminal Damage Act 1971, Section 1 of the Theft Act 1968. Look at appropriation, Section 3, Gomez case 1993, dishonesty, the Gosh test. Property, Section 4, and belonging to another, Section 5, the intention to permanently deprive. We also looking at the key terminology. So what does criminal liability actually mean in regards to elements of it, and what is criminal damage, and the Criminal Damage Act 1971, and what that defines as being criminal damage for an individual. So the next slide, we're looking at a video on criminal damage and the looking at different types of criminal damage and how it applies in regards to mens rea and actus rea. So criminal damage and theft are two offences under UK law. And as we mentioned, criminal liability for criminal damage and theft requires both the intent to commit the crime and the actual act of committing the crime. So it has to have both the actus reus and the mens rea as well. So for the criminal damage, the defendant must have intentionally damaged another person's property. The defendant must have lacked a lawful excuse. And prosecutors in criminal damage must prove the defendant intended to cause that damage. So in regards to criminal damage, examples of criminal damage include things like arson, forced entry into a property, graffiti on a public building, and destruction, damage of items belonging to another. Even if the items are damaged, can be repaired, individuals can still be actually prosecuted for that. So it's such a charge can be subject to penalties, including fines and possible imprisonment. The offences of criminal damage are set out in the Criminal Damage Act 1971. And the authorities will need to establish the following elements to proceed. So they need to establish the exact damage that was caused. They would need to establish that the damaged property belonged to another, and also the damage was caused without lawful excuse. Criminal damage can also be deemed as committed recklessly, which means that there was no intention to cause criminal damage. A person acts recklessly with respect to the circumstances when they are aware of the risks that exist or will exist. In the circumstances known to them, it was unreasonable to take the risk. An example of reckless damage could be kicking a ball to someone. You miss them and end up damaging someone's property. Is this just an accident, or do you appreciate you could damage the property but didn't move to a safe distance away? You know, there's certainly a fine line at investigation. So it's sometimes quite difficult to prove that and to identify that. So it's really important when you look at criminal damage to identify the severity of the damage as well, and whether, you know, the person who's committed the damage, you know, whether they were lawful or not. And also the cases examples for this were the case of Rowe and Kinnelly, 1986, where mud was smeared on a wall was considered damage as it required cleaning. In regards to Jackard and Dickinson, 1981, the defendant believed the owner would consent, providing a lawful excuse. And then the popular case, which we mentioned in Learning Outcome 2 as well, is R and Cunningham, 1957, which involves awareness of a risk and acting regardlessly of that risk. The next element of the next slide looks at aggravated criminal damage. Aggravated criminal damage is a person who, without lawful excuses, destroys or damages any property, whether belonging to himself or another, and the offence can be punishable by, a sentence. Deliberately causing damage or destroying the property of another person is criminal offence. So, aggravated criminal offence is endangering someone's life through the description of damage. And the case example for that was the case of R and Steer 1987, where the endangerment must result from the damage caused, not other factors. And another example is racially aggravated criminal damage, where a person may be charged under Section 30 of the Criminal Crime and Disorder Act 1998 if they cause damage or destroy property which is motivated by racial or religious hostility or prejudice. The next slide is looking at theft and looking at the elements of theft, how that would amount to an offence as well. So the offence of theft is set out in Section 1 of the Theft Act, which provides that a person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it, and thief and steal shall be construed accordingly. And the actors raise appropriation of and then the property, and then belonging to another. So the first one is appropriation. Section 3(1) of the Theft Act 1968 defines this as any assumption by a person of the rights of an owner amounts to appropriation, and this includes where he has become by the property without stealing it, any later assumption of a right to it by keeping or dealing with it. Put simply, this means citing in relation to the property as if you are the owner of the said property. And indeed, R and Morris case, a really popular case, again on the slides, confirmed that an appropriation was not just physically taking the property, but could be achieved, for example, by doing an act, any act that only the owner has the right to do, for example, by selling it. So in the R and Morris case, 1983, the defendant switched the price labels in supermarkets so that when they reached the checkout, they were unknowingly charged at a lower price than intended by the shop assistant. The defendant was charged with theft but protested the charge, claiming no appropriation took place. The House of Lords held that an appropriation did not require the assumption of all the rights of the owner, merely an adverse interference with the rights which the defendant had done then when switching the labels, an act which reserved by the owner for their exclusive doing. An appropriation will still occur where the defendant has the right with the owner's permission, but then exceeds this permission by assuming the rights of the owner. For example, they have been lent a DVD and have it in their possession with the permission of the owner, but then exceed the permission by deciding not to give it back or by putting it on eBay. Another really famous case in regards to that is the case of R and Gomez, which confirmed that an appropriation can occur even when the owner of the property gives consent. So the property one is a Section 4 of the Theft Act 1968 defines property in great depth, stating property includes money and all other property, real or personal, including things in action and other intangible property. This definition is very wide and most objects will fall within the scope of it. The incorporation of words things in action and intangible objects extend the meaning of property to cover rights such as those provided by shares or copyright. A very famous case in regards to that is the case of Oxford and Moss, where a student accordingly could not be guilty of theft of the contents of an exam paper. The next one is belonging to another, and Section 5 of the Theft Act 1968 states that another person must have possession or control of the property in order for it to be considered to belong to another. The effect of the requirement possession or control and not simply ownership means that a defendant could be liable for the theft of his own property. So this was demonstrated in the case of R and Turner, number 2, 1971, where the defendant, who had left his car at a garage for repair, picked it up without paying for the repairs. As for the car was in the possession and control of the garage at the time in question, the defendant was liable for the theft of his car. Section 5(3) of the Act states that where the possession of property is given to another with instructions to deal with it in a certain way, the ownership in the property is deemed to remain with the giver. So the mens rea is dishonesty, defined in Section 2 of the Theft Act 1968, which provides a negative definition of what constitutes dishonesty by setting out 3 situations where a defendant will not be deemed dishonest. Firstly, if he appropriates the property in the belief that he has in law the right to deprive the other of it on behalf of himself or of a third person, or B, if he appropriates the property in the belief that he would have the other's consent if the other knew of the appropriation and circumstances of it, or C, if he appropriates the property in the belief that the person to whom the property belongs cannot be discovered by taking reasonable steps. It is important to know that these are all judged subjectively, and there's no requirement that the defendant's beliefs were reasonably held. In addition to Section 2, subsection 2 provides that a willingness to pay for the property will not negative any dishonesty. For example, taking a mug from a colleague's desk and leaving £5 note to account for it would not remove the dishonesty of taking the mug. Outside the specific situations provided by the Act, the courts apply a common law test set out by Lord Lane in the case of R and Gosh, 1982. The test provides a 2-stage assessment in determining dishonesty. Firstly, was the defendant dishonest by the ordinary standards of reasonable and honest people? And secondly, did the defendant realise that he had been dishonest by those standards? Next one is intention to permanently deprive. And this is where the victim need not actually be permanently deprived of their property so long as the defendant held the intention of permanently depriving them of it. In accordance with the wording of this element, the of mens rea borrowing, even without permission, will not amount to such intention as if the defendant intended to give it back, then he clearly does not intend to permanently deprive. And the case of that is the case of R and Vemlen, 1989, where borrowing money with the intention to return equivalent but not the same notes constituted theft. So the comparison table looks at the aspect of the legislation, actus reus, mens reus, key cases for actus reus and key cases for mens rea with reference to criminal damage under the Criminal Damage Act 1971 and the theft under Theft Act 1968. So you can have a look at that in your own time. The legal liability requirements for criminal damage and theft ensure that offences are assessed both on the defendant's actions and the mental state, which is the mens rea. These elements are supported by legislation and case law to provide a legal framework and a fair framework for determining any sort of criminal responsibility. Definitions of criminal damage, aggravated criminal damage. So criminal damage, as we said, is an act of damaging or destroying another person's property without a lawful excuse. Aggravated damage is when the damage is intended to endanger someone's lives. So we're looking at criminal damage. As we mentioned earlier, criminal damage is the element of defined under Section 1 of the Criminal Damage Act 1971 as the destruction or damage to property belonging to another without lawful excuse. Key elements are destruction of damage, which is in the case of Rowe and Kingerley, where smearing mud on the wall constituted damage. Property is defined under Section 10(1). And mens rea, the case of R and G 2003, where 2 boys set fire to newspapers, leading to extensive property damage, and the court ruled that recklessness is subjective and based on the defendant's actual awareness of the risk. Aggravated criminal damage. We looked at that a little bit earlier as well, so I'll just go through that. So aggravated criminal damage, as we mentioned earlier, means there was also an intention to endanger someone's life through the destruction of damage of property. And the key elements here are, like we said, destruction or damage and endangered to life, and the case of Aaron Steer in 1987. And then the mens rea is intention or recklessness as to causing damage with awareness that life could be endangered. So now we're going to go look at our elements of theft and the key elements of it: appropriation, property, and belonging to another, and the mens rea, dishonesty, and intention to deprive. So the first one, the theft is defined, as we said in section 1 of the Theft Act, as dishonest appropriation of property belonging to another with the intention to permanently deprive of them. So the first one, key element, is appropriation, and that is defined by section 3 of the Theft Act 1968 as assuming the rights of a legal owner of the property without consent. A legal owner has the absolute right to use this property for a particular function. A good example would be a car. An individual owns the vehicle and chooses where they drive it to and who they give their permission to use it. If another individual removes the vehicle and drives it away without the owner's permission, that this is deemed appropriation. Following on from this is when an individual is given permission to use the vehicle by its owner and they do not return and have no intention of returning the vehicle to its owner. This again is deemed appropriation. Then for the property, the key element, property includes money and numerous other items belonging to another. Tangible and intangible items. Personal property includes property other than land, such as vehicles, electrical appliances, antiques, and all other physical objects. Real property means land and anything fixed to the land, including houses and outbuildings. Belonging to another is under section 5 of the Theft Act. Property belongs to another person if that person has possession or control of it. And then dishonesty, which is the mens rea, is determined in 2 ways and identified by the courts. According to the ordinary standards of reasonable and honest people, was the act carried out dishonestly? If it was dishonest by those standards, did the defendant realise that the reasonable and honest person would regard the conduct as dishonest? If it will be a defence to a theft charge if you can show that you had a genuine belief that you had the legal right to appropriate the property. The owner would have consented, or the owner cannot be traced by taking reasonable steps. In the case of Genting Casinos 2017, I looked at whether the defendant's actions were dishonest according to the standards of an ordinary reasonable person. Then we've got intention to permanently deprive. And this is arguably the most difficult element to prove. However, in many cases, it will be evident that this is satisfied before prosecuting. For instance, if someone was to run out of an electric shop holding a TV without paying and get into a waiting car, it should be apparent that the offender intended to do this and leave without making payment. So a case in regards to that is the case of Aaron Vellemil, 1989, which I went through earlier with you. So defences under the Criminal Damage Act 1971 include things like consent, which is if you believe the owner consented to the damage, belief in the protection of property, if you damage property to protect your own or someone else's property. You've got immediate self-defense, so if you use reasonable force in self-defense, which we'll go through later. Immediate need, so if the property needed immediate protection. Another one is life, injury, or imprisonment, so if the damaged property to prevent injury, stop unlawful imprisonment, or save life. Summary table here identifies the offences: criminal damage, aggravated damage, theft, with reference to definition, key elements, mens rea, and key cases such as Rowe and Kingerley, Aaron Steer, Aaron Morris. So in conclusion, criminal damage and aggravated criminal damage and theft involved distinct elements under the Criminal Damage Act and Theft Act 1968, and the distinction between these offences is crucial for determining liability and the defences. And this case law is used to make sure that the criminal justice system is fair and everything, ensuring any sort of clarity as well. Defences to criminal damage. And that is looking at 3.2. So if you if there are any sort of defences when it comes to criminal damage, it would be identified in regards if the acting individual believed that the victim honestly and sincerely consented to the damage, there's potential defence to criminal damage allegations. If the individual acted to protect property belonging to himself or another, there's possible defence again. Key defences to criminal damage. So as we mentioned, you've got the element of appropriation, which is section 3, which application to criminal damage is a defendant may argue they were appropriating the property under lawful belief or consent. Example of that is the case of R and Gomez. And then 1993, and then you've got dishonesty, which is the element of the Gosh test, 1982, and the case of Ivy, 2017. Then you've got the property section 4, which we went through earlier. Property includes intangible items, but excludes intangible assets like information or electronic data. They belong to another, section 5. Property is considered to belong to another with the possession, control, or proprietary rights. And then intention to permanently deprive, section 6, intending to treat property as one owns to the exclusion of the rights of the owner. And that was the Venerum case. So summary table looks at appropriation, dishonesty, property belonging to another, and intention to deprive with reference to the definition, the key cases and the application, and looked at the defences as well. So defences to criminal liability. Damage under section 3, 4, and 5 of 6 of the Criminal Damage Act provides opportunities for defendants to avoid liability where they acted with honest belief, without dishonesty or intent to deprive the other. The evolution of dishonesty test in Gosh test ensures that defences remain fair and balanced. Analysis of actus reus and mens rea elements of criminal damage. So in criminal damage, the actus reus refers to the act of destroying or damaging another's property without lawful excuse, while the mens rea is the mental state of either intentionally causing damage or acting recklessly regarding the likelihood of causing damage to property belonging to another. Essentially, the defendant must have either intended to damage property or been aware of a significant risk of damage and proceeded anywhere. The actus reus of the guilty mind. So the actus reus of criminal damage offence is the action that causes harm to the property. This damage could include breaking, burning, or making the property unusable or significantly reducing its value, whether temporarily or permanently. Simply causing a mess that is easily cleanable is unlikely to constitute criminal damage. You've got the element of destruction of damages or damage, which is the case of refers to any action that reduces the value, utility, or normal use of the property. And the case is Rowe and Kingley. Removal paint on a wall was deemed damage. And then property defined broadly under section 10, subsection 1 of the Criminal Damage Act 1971 to include tangible items like personal belongings and real estate, excluding intangible property. And the case in regards to that was a case called Cox and Riley, 1986, which extended this to computer software, showing the law's adaptability. Then you've got the next one is belonging to another, and the property must be owned, possessed, or controlled by someone other than the defendant. Even a partial interest by the defendant meets the requirements, as in the case of R and Whiteley, 1991. The case example is the popular case of Turner number 2, 1971. And causation, the defendant's actions must direct cause the damage or destruction. the mens rea for guilty mind is the first one, intention. Intention or recklessness. The defendant must intend to cause damage or act recklessly in the case of R&G 2003. Whereas recklessness in that case was the notable case reshaped the understanding of recklessness in criminal damage, where two young boys accidentally caused an extensive fire damage with fire. The House of Lords shifted from an objective to a subjective recklessness standard, and the key points in this case were whether there requires actual foresight of risk. The risk must be unreasonably taken, and it aligns with other areas of criminal law using subjective recklessness. So the intention obviously looks at the recklessness, and the next one is the knowledge of, there's also knowledge of the belief as well, in whether a genuine, even mistaken belief that the owner would consent, as in the case of Jacquard and Dickinson, 1981, where intoxication led to a mistaken belief. Without lawful excuse. The Criminal Damage Act 1971 defines someone who causes criminal damage a person who, without lawful excuse, destroys or damages any property belonging to another, intending to destroy or damage any such property, or being reckless as to whether any such property would be destroyed or damaged without any justification. So the Criminal Damage Act states that someone who damages property without a lawful excuse is guilty of an offence. The Act includes the intention to damage property or being reckless about the damage. An example of acting with lawful excuse is a police officer who damages a door to execute an arrest warrant. The Criminal Damage Act 1971 also states that an honestly held belief is not required to be justified. For example, if someone sets fire to a building to highlight the lack of fire defences, they may claim a lawful excuse. However, the court may rule that their intentions was not to protect the property. Without lawful justification means that the defendants contrive to accomplish some criminal or unlawful purpose, or to accomplish some purpose not in itself criminal or unlawful by criminal or unlawful means. And the popular case in regards to that is the case of Jacquard and Dickinson, 1981. This case highlights the defence of lawful excuse based on mistaken belief. An intoxicated defendant damaged a door, mistakenly thinking it was her friend's house. And the key points that were identified in this case is a genuine mistaken belief in consent qualifies as lawful excuse, and intoxication is relevant to the belief's genuineness, and it emphasises the subject nature of the defence. So application of actus reus and mens rea. To prove criminal prosecution, the prosecution must establish actus and mens. Actus rea, and as we said, are the legal concepts that are used together to determine if someone is criminally liable. Actus reus is the physical act of crime, while mens rea is the mental state of the offender. Actus rea involves the actions of the offender, including both affirmative actions and failures to act. The specific actus reus required depends on the crime. For example, in a murder crime, the actus reus is the killing of someone. Mens rea involves the offender's intent, knowledge, or state of mind at the time of the crime. The most common level of mens rea is intent, but other levels include recklessness and negligence. The existence of mens rea shows that the defendant's mind was criminally culpable. Case examples highlighting actus reus and mens rea. So the first case, as we mentioned earlier, these have been mentioned earlier on as well. I'll just give you a little bit of an overview of the actus and mens for each case. So Rowan Killingley, 1986, where the actus reus is the mud smeared on a wall, required cleaning, constituting damage. The mens rea in this case was the defendant intentionally caused the damage. The R against G case 2003, the actus reus was the fire caused significant damage to the property. The mens rea is the court focused on whether the defendant were aware of the risk, damage, ruling recklessness requires subjective awareness. And the case of Jacquard and Dickinson 1981, the actus reus was breaking a window. The mens rea was the defendant had lawful excuse as to their mistaken belief that they had the owner's consent. So in the summary table, it looks at elements of destruction or damage of property belonging to another and lawful excuse. Looked at the actus reus, which is the guilty act, and the mens rea, which is the guilty mind, with reference to really important cases that identified elements of each of these: destruction or damage, property belonging to another, and lawful excuse. So in conclusion, the actus rea of criminal damage involves proving physical damage to property belonging to another, while the mens rea requires demonstrating intent or recklessness. These elements, as established in the Criminal Damage Act 1971, ensure that liability is assigned only when the physical act and the guilty mind align, supported by legal principles and cases which we've looked at. Analysis of actus reus and mens rea elements of theft. So in the crime of theft, the actus reus refers to the physical act of appropriating belonging to another, while the mens rea is the mental element of acting dishonestly with the intention to permanently deprive the owner of that property, essentially meaning the defendant must physically take someone else's property while knowingly and intentionally intending to keep it permanently. So we've been through some of the key elements. We'll go through them a little bit more so you've got a bit of an understanding, okay? So the actus rea of theft, the first one is appropriation, which is section 3, and this is the act of assuming the rights of the owner, and consent is irrelevant here. And the case here is the R and Gomez case 1993, where a store manager was deceived into accepting stolen checks. The defendant's actions amounted to appropriation despite the manager's consent. Then we've got the case of R and Hinks 2000, which is receiving a gift dishonestly was held to be appropriation. Then we've got the element of property, which is section 4. And in regards to the element of property in section 4, it looks at the element of property, which is the item must be considered property under the law, including tangible items, money, and sometimes intangible rights. And that is the element and the case of Oxford and Moss 1979, where exam questions were not considered property. And then belonging to another is section 5 of the Act, which looks at the property must belong to someone else, meaning they have possession or control over it. Courts have developed case law to define the nuances of appropriation and dishonesty, such as the assumption of any other owner's rights principle from the case of R and Morris, which is the most famous case in regards to that. Mens rea of theft. The mens rea of theft is the first element is dishonesty, which is the element of theft is about what is considered dishonest. So, you may have different ideas of what is considered dishonest, what the facts as the defendant believed them. A case, really important case in regards to that is the case of R and Barton and Booth 2020, where it looked at the court confirmed that dishonesty is determined by an objective standard following the IFA test. The IFA versus Genting Casinos 2017 case established the dishonesty test for theft. The IFA test replaced the Gosh test from R and Gosh 1982. The Gosh test required the jury to ask themselves two things. Was what the defendant did dishonest according to the standard of reasonable and honest person? And secondly, if so, did the defendant realise that reasonable and honest people would regard what he did as dishonest? The Gosh test was highly criticised over the years, and critics believe that there should be more guidance and that juries might apply the test in different ways. The issue was solved in IFA case by the Supreme Court in a civil matter. In this case, the Supreme Court removed the second limb of the Gosh test. Therefore, the defendant is judged on the basis of his or his actual knowledge or belief as to the facts. It's important to remember that in many cases, the issue of dishonesty will be clear. Section 2 of subsection 1 of the Theft Act will have no relevance in majority of cases, and the IFA case will not be used in every case to determine dishonesty, as it should only be used if the jury needs guidance. If dishonesty is apparent of the facts of the case, there's no need for the test. Next one is intention to deprive, permanently deprive, which is section 6. The last element of mens rea of theft is that the defendant would also have the intent to permanently deprive the other property he has appropriated. Usually the words intention to permanently deprive will be given their ordinary meaning. The case of R and Velleman, 1989, confirmed that if person A takes money from person B intending to repay it, there definitely is an intention to permanently deprive. Person A always intended to deprive the owner, person B, of the particular notes and coins that A took. Again, the fact that A intended to pay the owner back in an equivalent sum is relevant only to the question of dishonesty. And another case example is the R and Lloyd's case, 1985. Section 6 of the Theft Act states that a person appropriating property belonging to another without meaning the other permanently to lose the thing is in itself nevertheless to be regarded as having the intention to permanently depriving the other of it, if his intention is to treat the thing as his own, to dispose of regardless of the other's right, and a borrowing or lending of it may amount to so treating it, but only if the borrowing or lending is for a period and in circumstances making it equivalent to an outright taking or disposal. The provisions set out in section 6(1) shows that if someone appropriates property and treats the thing as his own to dispose of regardless of the other's rights, there's sufficient enough to establish this element of mens rea. In the case of R and Lloyd, it was confirmed that section 6, subsection 1 should be referred to as in exceptional cases only. In Lloyd, it was determined that if an item was borrowed, then there's still value attached to the property. Once it will not amount to theft. Application of actus reus and mens rea. So the actus rea, defendant appropriated property belonging to another, and the mens rea is the defendant acted dishonestly intended to permanently deprive the other. We've got the summary table, which looks at the element of appropriation, property belonging to another, dishonesty, and intention to permanently deprive, with actus reus with the guilty act, the mens rea the guilty mind, and the key cases in regards to that. So in conclusion, the offence of theft requires the prosecution to prove both actus reus and mens rea. The actus reus focuses on appropriation property and its ownership, while the mens rea involves dishonesty and the intention to permanently deprive. The combined elements ensure that only those who unlawfully and unknowingly violate others' property rights are held liable. Case law and statutory definitions provide clarity on how these principles are applied. So now we've finished learning outcome 3. I'll just give you a recap of what we did in learning outcome 3 so you've got a better idea. So in learning outcome 3, we looked at the understanding the legal liability requirements for criminal damage and theft. We looked at the Criminal Damage Act 1971. We looked at the aggravated criminal damage. Looked at Section 5 of Criminal Damage Act, belief in consent. We looked at the Theft Act, Section 1, 1968. We looked at appropriation, Section 3, and Gomez case, 1993. We looked at the dishonesty with the Gosh test as amended by IFA in 2017. We also looked at Barton and Booth and property section belonging to another, and the intention to permanently deprive. We looked at aggravated criminal damage. We also looked at theft in detail and definition of criminal damage, aggravated damage, and theft. We also looked at defences under Criminal Damage Act 1971. And we also looked at defences to criminal damage, such as appropriation, dishonesty, and property and belonging to another. We looked at the analysis of actus reus and mens rea elements of criminal damage, and also looked at the application of actus reus and mens rea to prove any elements. We also, whilst looking at elements of actus and mens with regards to criminal damage and theft, we also looked at cases in regards to this, and we looked at popular cases such as Rowe and Kingerley, 1986, R and G, 2003, and Jacquard and Dickinson, 1981. We also looked at elements of analysis of actus reus and mens rea elements of theft. We looked at key elements of actus rea appropriation, property and belonging to another, and used case examples such as Oxford and Moss and R and Barton. So that was learning outcome 3. So now we finished learning outcome 3. These are some of the references we've used for today's session. The next learning outcome is learning outcome 4. And these will all be recorded and put onto Moodle. Refer to ebooks and journals on Moodle for this, and also further reading. I've put a link on there, and that looks at criminal damage and the legal system in regards to any forms of criminal damage for theft and the liabilities under criminal damage. So have a read of that. All the recordings from learning outcome 1, 2, and 3, which is today's session, will be put onto Moodle for you, and any sort of additional reading, any resources. The link for the additional sample material PDF document is there for you to read. Submission of the assignment is to be done on learnerwork@ukvarsity.co.uk. And if you have any question or queries, please email learnerwork@ukvarsity.co.uk. Thank you for attending today's session. The next learning outcome is learning outcome 4 that we'll be doing, which I'll see you there. Thank you.